है? हाँ ठीक
Serial
है।
number 50 is Sunil Kumar Singh, Rakesh Singh.
3:30 कर दीजिएगा मेंशन कैसे से। ठीक है प्लीज।
My lord, this petition, the prayer is of two folds, my lord. Firstly, annexure A1 at page 15, that is the order of attachment. Thousand 20 onwards, and till date it has not been completed.
तो ये आर्म फोर्स ट्राइब्यूनल में नहीं जाएगा क्या?
My lord, attachment is not a service matter, my lord, as per this rule, armed force tribunal rules, my lord.
जी
ये सेक्शन 11 कहता है, my lord, इसमें jurisdiction and powers से may I read this, my lord?
हाँ प्लीज प्लीज।
Say, section 11 says that, my lord, save as otherwise expressly provided in this act, the tribunal shall exercise on and from the appointed day all the jurisdiction, power and authority exercisable immediately before that day by all courts except the Supreme Court or the High Court exercising jurisdiction under Article 226 and 227 of the Constitution in relation to all service matter.
तो
And
डिसिप्लिनरी प्रोसीडिंग के कारण आपको अटैच किया गया है।
my lord, and service matter says that, my lord, that
डिसिप्लिनरी प्रोसीडिंग इज अ सर्विस मैटर एंड so
and
if you want any relief in regard to the disciplinary proceedings, as you said that your disciplinary proceedings are pending since 2020, you are required to approach armed force tribunal.
Even I've taken this objection also in my reply also, Your Worship. In
my
respect of the
submission is that,
maintainability
my
of
lord,
this.
they are
And the other action is consequential.
Yes.
The moment disciplinary authority disciplinary proceedings will come to an end, आप इसको विड्रॉ करके वहां जाइए आर्म्ड फोर्स
my
ट्राइब्यूनल में।
lord, my submission is that this attachment order is not a disciplinary
ठीक
matter.
है तो ऑर्डर ले लीजिए फिर
My lord.
मैरिट्स पे ले लीजिए
My
लिखिएगा
lord, this attachment
has challenged order dated 6th April 2023
my lord, my submission is one more
attaching the
submission.
petitioner to the unit GR League HQMB area. Full stop. Petitioner is also claiming relief that his departmental proceedings are pending since 2020 and they be directed to be disposed of expeditiously. Next para. As for Shri Vikram Singh Learned, Counsel for the Union of India, in his turn submits that disciplinary proceedings are subject matter of jurisdiction of Armed Force Tribunal and they cannot be looked into. Next paragraph. Though Shri Rakesh Singh submits that attachment is not a subject matter which can be agitated before the armed force, but fact of the matter is attachment is with the unit for the purposes of disciplinary proceedings and therefore there being nexus between the disciplinary proceedings and the order of attachment, comma, and order of attachment being consequential to the initiation of the disciplinary proceedings and disciplinary proceeding falls within the armed force tribunal jurisdiction to hear and decide this case will lie exclusively within the domain of the armed force and therefore without commenting on merits petitioner is relegated to avail the remedy as may be prescribed under the Armed Force Tribunal Act.
Lordship, there is a full bench of the original tribunal also, which has already been dealt by this aspect that if the attachment pursuant to disciplinary proceeding is
Right.
also done, my lord, that is not falls within ambit of service matter. This is the full bench of the OFT.
क्या कहा बताइए?
Last one, my lord.
जी. Last.
So, in this case also, my lord, the attachment has been done.
Last paragraph.
My lord. Yes, my lord. From the observations of Honorable Apex Court in the case of Dharamveer and Singh case and our deliberation given aforesaid, we are of the view that as per definition of the service matter given in the clause shall not include relating to section 302 of the Armed Force Tribunal Act, the issue formulated as referred in para 4 above is answered. The attachment order issued under Army Instruction 3086 and the Army Order so and so will fall under the exceptions provided under section 302 of Armed Force Tribunal as so as to exclude it as a service matter unless very compelling, extraordinary and exceptional case is carved out on facts for indulgence of the tribunal. Subsequently,
What was the
Purushottam
issue
Das-
which was whether the attachment order issued under itna and itna is a posting transfer falling? It is not a transfer posting, that is true. लिखिएगा ऊपर लिखिएगा petitioner has placed reliance on a
Subsequently, in Purushottam Das also, this has been dealt with by the Honorable Apex Court.
ठीक है has placed reliance on the full bench decision of the Armed Forces Tribunal, Principal Bench, New Delhi in OA 965 of 2017 with MA 967 of 2018, Major General M.S. Jaswal versus Union of India and others. So also OA number 404 of 2018 with MA 425 of 2018, Lieutenant Colonel Ranjit Singh versus Union of India and others with OA 655 oblique 2018, Colonel S. Satish Prabhu versus Union of India and others, that wherein answering the response reference that whether within inverted commas whether the attachment order issued under Army Instructions 30 of 30 oblique 1986 and Army Order 7 oblique 2000 is a posting oblique transfer falling under the exception provided under section 3 within bracket O bracket close another bracket small Roman 2 bracket close of the Armed Forces Tribunal Act 2007, comma, so as to exclude it as a service matter, inverted commas close. Answering this reference, the full bench of the Armed Force Tribunal has held as under within double inverted commas the single inverted commas attachment order inverted single inverted commas close issued under Army Instruction 30 oblique 1986 and Army Order 7 oblique 2000 will fall under the exception provided under section 3 within bracket O another bracket Roman 2 of the Armed Forces Tribunal Act, comma 2007, comma so as to exclude it as a within single inverted commas service matter in single inverted commas close, comma unless very compelling, extraordinary or exceptional case is carved out on facts for indulgence of the tribunal, inverted commas close. Next paragraph. Reliance is also placed on the judgment of Supreme Court in Union of India and others versus Purushottam Das 2023 SCC Online SC 314
Para 32, my lord, in which it is right that the
wherein it is held that judgment in Major General Shrikant Sharma does not, Shrikant Sharma case does not lay down the correct law and is in conflict with judgments of the constitution benches rendered prior and later to it, comma, including in L. Chandrakumar case, comma, S. N. Mukherjee case, and Roger Matthew case, making it abundantly clear that there is no per se restriction on the exercise of power under Article 226 of the Constitution by the High Court. Full stop. However, comma, in respect of matters of self-discipline, comma, the principles already stand enunciated. Full stop. In view of said judgment, it is submitted that High Court has jurisdiction. Next para. There is no dispute about the legal proposition as to the jurisdiction of the High Court, but fact of the matter is that since in the petition, petitioner has claimed relief of not only quashing of the order dated 6/4/2023 issued by the respondents, but has also sought relief directing the respondents to conclude the disciplinary proceedings in a stipulated time frame in the interest of justice. कितना टाइम लगेगा आपको?
3 years का तो स्टेशन में प्रोवाइड ले also.
तो अभी कब शुरू हुई थी?
122 will also. Summary of evidence has already been concluded so far as the petitioner is concerned also. There are 4 other accused persons in respect of whom also the summary of evidence has to be concluded, and after that the meeting would be convened just to decide whether the trial has to be
कितने टाइम
commenced or
में,
not.
कितने दिन में हो जाएगा ये?
Also, if there are 4 other accused persons also, still we have the time also. The time which has been
3 साल का
prescribed
time
in
है।
the act also 3 years.
2020 में चार्जशीट दी थी ना आपने?
Yes. No. Also, from the date of the direction when the disciplinary proceeding has to be initiated, that is 8th of February 2023 also. So the limitation will start from this date itself.
Court of inquiry initiated in the month of February 2020, my lord. From since 2020.
प्रोविजन बताइएगा, वो प्रोविजन बताइएगा, 3 साल का जो लिमिटेशन
Yes. 122 also.
122 itself says.
हाँ, दीजिएगा.
The law just make I appreciate 122B, where the commission of an offence was not known to the persons aggrieved by the offence or to the authority competent to initiate action, the first day on which such offence comes to the knowledge of such persons or authority, whichever is earlier.
जी फिर
3 years के तरफ.
ये तो 3 साल का पीरियड तो दिया है टू कमेंस द प्रोसीडिंग्स.
Yes.
कंप्लीशन का क्या पीरियड दिया हुआ है? आप गलत तो मत बताया करिए मिस्टर विक्रम सिंह.
Lordship, 3 years is from
3
the
years
date
to
of.
complete. There are two different things.
Yes.
Section 122 says period of limitation for trial, except as provided by subsection 2, no trial by court martial of any person subject to this act for any offence shall be commenced after the expiration of a period of 3 years.
3 years.
So that is to initiate the proceedings. That is not to conclude the proceedings.
No. So we have not started the trial, Lordship. It has to be decided whether the trial has to be commenced against these persons or not. It has been the stage of preemptory jurisdiction, Lord. And this Lordship may kindly appreciate.
And such period of 3 years shall commence on the date of the offence or where the commission of the offence was not known to the person aggrieved by the offence or to the authority competent to initiate action, the first day on which such offence comes to the knowledge. 2020 में आपको नॉलेज में आ गया ये?
No.
कब आया आपकी नॉलेज में? बताइए. हाँ मैडम, आप बताइए.
Your Lordships, Your Lordships, in 2020, when there was a surprise raid, there was some excess stores found. Accordingly, we started a
Extra stores were found.
yes, some
Yeah.
clothing irregularities. Certain stores were mismatching from the control vouchers.
Ji.
Accordingly, we ordered a court of inquiry, which is a fact-finding body. It
Ji.
is akin to a police investigation.
Ji.
When we completed that court of inquiry, that
When was it
investigation.
completed?
I'll just tell you, Lordships. वो page आपका clear है? It completed 23rd of 20, sorry, it completed on 8th February 23. That is when the knowledge,
Initiated in 2020.
Your Lordship, the surprise check happened on January 20. After that, the court of inquiry was convened August 20,
Uh,
21st
it's a
August.
January 20 surprise check.
Yes, that's where we realized that certain clothing irregularities under.
That is the time on the date when you came to know of the offense.
But we did not know who all, if how many people are involved in this.
20 में court of inquiry हुआ.
We convened a court of inquiry which got concluded, and finally the competent authority came to the direction that a total of 9 people have committed various lapses,
जी.
out of which one of the individual is the petitioner in the instant case.
जी.
So when
समरी बनाकर दीजिए, इसको सुनते हैं, सब काट दीजिए, इसको लिखिएगा, आपका शुभ नाम बताइएगा.
Major Mohitma, Your Lordships.
Major
Mohitma.
Mohitma prays for time to give a summary of the events, so to point out as to whether the matter is within the period of limitation, so to fulfill the requirements of section 122 of the Army Act 1950. कितने दिन में देंगे आप summary?
2 weeks, Your Lordships.
Prays for and is granted 2 weeks time to do the needful list in the week commencing 29 जनवरी 2024.
Obliged.
Serial number 51,
आप भी कुछ नहीं लिखने की.
serial number 51, Sri Kumar Nape.